Ms. Lundy, everybody may be seated, and I apologize for interrupting you in the middle of closing.
I'm
The
terribly.
behavior from Mr. Bloom, I am not going to have in terms of his gestures, his noise and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I can.
No, Your Honor, thank you.
All right, very good. Parties prepared for closing argument? You may proceed.
May I move the question?
Depends on where you want to put it, but yes, you may go.
Rotate it very slowly.
That's all right. That's
Thank you. Good afternoon. When we started this morning, I let everyone know what I expected the evidence would show. Started talking about that Rocky Isley was a nurse working in the jail, and on that date, the defendant was incarcerated in the jail. Talked about how we were going to hear from different witnesses about the defendant reporting to experience a medical emergency. We've heard from 3 different witnesses. First, from Officer Naveen, talked about how that was his assignment that day. The defendant had been upset that day. He talked about how he was upset even earlier in the day. He understood that the defendant was upset about something that had happened before Officer Naveen had even gotten there that day. We heard that he cannot ignore anyone's request for a medical emergency. Because Officer Naveen, Officer Tweedale, and Nurse Rocky Isley have a responsibility to make sure that the people in the jail are safe. That's their job. The corrections officers are there to make sure that the folks who are in the jail are okay. They don't make the decisions about who goes there. They don't make the decisions about who leaves. Their responsibility is safety. Officer Naveen is talking about how he checks every 15 minutes, make sure the people that are in his cell block are okay. He talks about how he makes sure Mr. Bloom is okay. Nurse Rocky tells you about how it's his responsibility when someone says they're experiencing a medical emergency. He doesn't care how old they are. He doesn't think something's more or less likely based on their age. He doesn't think something's more or less likely based on who they are. He is there to make sure they are okay. Officer Tweedale is the one who speaks to the defendant and says to him and gets him to calm down enough to be medically evaluated. Why? Because it's his job. That's his job. He's got to find a way to communicate with each person to help them. Nurse Rocky, I'm sure everyone has experienced a nurse who made you feel safe, who made you feel cared for and listened to. And Officer Tweedale, when this is going to go down and he knows that Mr. Bloom has been upset, and he knows that Mr. Bloom has been agitated. He told you how he levels his hand above the food slot door just in case. Why would you do that? Just in case. Safe. But the only person out of these 4 men who didn't care about the safety of another person was the defendant. You're going to get jury instructions in a few minutes that display for you and educate you that the law does not allow sympathy nor prejudice to influence when you are making this decision. You should not be prejudiced against the defendant because he was incarcerated. And nor should you be sympathetic to him because he was incarcerated. The law requires an examination of the facts. And the facts are simple. The facts are the defendant was in the jail in Washtenaw County. The facts are that the defendant said he was having a medical emergency. The facts are that earlier in that day, he'd been very upset he was not allowed to get out of his cell. The facts are that he was a level 1 security. The facts are that he had to be medically evaluated to the wall, or into his door, rather. Now, I can't tell you what defense argument there might be, but I will tell you that you've seen a video, not my favorite angle. You've seen medical records, and you've got a copy of Rocky Isley's own statement that he made on May 31, the day after this happened in the night, about what happened. Everyone has a right to be safe at work. Everyone has a right to be safe at homes. All of the witnesses that you've heard from today helped to keep the defendant safe at his home. His home he didn't choose. He didn't choose to be in the jail, but that's where he was. Each of those men told you how they made a choice to keep him safe, despite his behavior, despite his influence.
Stop for a moment.
I'm sorry,
I
Your Honor.
apologize. Mr. Take the jury, please.
I'm so sorry, Your Honor.
No, it's not you. It's not you. Take the jury, please. Ms. Lundy, everybody may be seated. And I apologize for interrupting you in the middle of closing.
I'm
The
terribly.
behavior from him, from Mr. Bloom, I am not going to have in terms of his gestures, his noise and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I continue. Take him back. Court is standing in recess.
All right.
United District Court of County, Washington, State of Michigan is now back to session.
You may be seated. And if we can bring Mr. Bloom up, please. Court recalls the case of the People versus Jeffrey Bloom.
People.
Good afternoon, Mayor. Sam Bernstein with and on behalf of Mr. Bloom.
And as I've apprised counsel, during the course of the trial, Mr. Bloom, I don't know, and I'm going to assume that at least for these purposes that you weren't doing it intentionally. There have been comments which I could hear all the way up here, and I'm sure the jury could hear it during the course of these proceedings. That then, when Ms. Lundy got up to give her closing argument, there were additional comments I didn't. Mr. Bernstein.
I was going to say there were some times where Jeff was speaking with me during the trial.
Oh, I understand that, but there were other points at which there were just extraneous comments. So I was letting those go, but I'm not going to have that and have counsel interrupted during the course of their closing arguments. With that admonition, are the parties ready for the jury?
Your Honor, I also understand there's been information given to the jury that.
Correct. Yes, for the purposes of the record, I did inform counsel. So at no, that the jury did not take that in any way to be applicable either to Mr. Bloom or to the people, because I had stopped Ms. Lundy in the middle of her closing argument. And I had indicated that they are not to take any delay or interruption by the court. They are not to attribute it to either party. They are to attribute it to the court of its own doing, so that the jury understands that and does not hold that against the people or against the defendant.
Thank you, Your Honor. I am ready to proceed.
Is the defense ready?
I am ready, Your Honor.
All right, let's bring the jury. What is going on? All right. Go ahead. Thank you.
Still hot
Oh.
We're, is he ready to, what's? Pardon?
I don't think he wants.
Sick, Your Honor.
No.
Yeah. Did you want to go back there and try to talk with him? Because in the record should reflect, if it doesn't already, that after the court's admonishment to defendant and asking whether or not the people in defense were ready, that the defendant on his own accord decided that he would leave the courtroom. I've been informed by transport that it appears that he does not wish to come back out.
I really should try to speak with him, Your Honor. I mean,
Yes, you should.
it's a significant right to be at your own, like in the Constitution or something.
One can, I believe, voluntarily forfeit.
That's fair too. Yeah.
So before we get to that stage, why don't I'll stand in recess and allow you to have an opportunity to chat. All right, thank you.
All right.
Ladies and gentlemen. Yeah, Alan's trying to put the jury out, so. All right. Okay, we're back on the record. Court does recall the case of the people of the state of Michigan versus Jeffrey Blum. Counsel, state your appearances.
Ashley Lonnie for the people.
Sam Bernstein for Mr. Bloom, Your Honor.
All right, Mr. Bloom is not present. If I say anything incorrectly, please, counsel, correct me. Just prior to our last recess, when we were trying to continue with the trial, after the people had begun their closing argument, I stopped the proceedings, gave an admonishment, had the jury removed, gave an admonishment to the defendant regarding comments that he was making, as well as gestures in terms of his hands, because of the positioning of the podium behind the prosecutor's back. Gave him that admonishment, then told him that I would not tolerate any of that behavior. At that point, I did not hear anything, or at least nothing that was audible or understandable from the court in terms of the defendant saying anything. The defendant got up and he removed himself from the courtroom. Transport took him back. I took a recess in order to allow Mr. Bernstein to speak with his client. I was then informed during the course of that from transport that Mr. Bloom did not wish to return to the courtroom. And so that's kind of where we were left. The question that arose as to whether or not this court, given the defendant's behavior, whether or not this court could continue with the trial, even though we just had closings and the verdict to go. Out of an abundance of caution, after speaking with counsel and the court looking up for some guidance in this regard, the court did find me, I think it's Rule 43. I didn't bring my copy out of the federal rules, which specifically address the issue where a defendant removes himself from a trial in the middle of the proceedings or doesn't elect to participate. I did not see a rule specifically in the Michigan court rules governing that. As I did a brief research in trying to find cases, the case of the people of the state of Michigan versus Jerry Oliver Swan, that being 394 Mich 451, came to light. It was a 1975 case, so it's a little bit old, but it still looks to be good case law. I gave that to council, asked them to take a look, see if we could, between all of us, make a determination as to what would be the best way to proceed. And granted, I don't think anybody's had an opportunity to do any extensive research on it. However, I would indicate that if nothing else, the Swan case is illustrative of a point. And the synopsis basically indicates the Supreme Court held the defendant did not reappear in the courtroom after a mid-trial recess, had not reappeared 4 days later, and testimony was received regarding attempts to locate him. Trial court properly proceeded with the trial with receiving,
And right out of the gate, the judge shuts it down. This isn't a casual courtroom scolding. In front of a jury, even eye rolls and hand gestures can plant doubt or bias. Judges guard neutrality like it's gold. So when the court says, "not gonna have it," that's a line in the sand. Ask yourself, if a defendant can't stay composed during closing arguments, what impression is that leaving on 12 jurors watching every move?
Part of the testimony in the jury's verdict in the defendant's absence. Taking that without anything else in front of me is sort of a guideline. The court believes that the defendant has conducted himself in a fashion where he has made himself absent mid-trial. It seems to me that what the Swan case seems to point to is that an opportunity be given where this defendant being in custody, we don't have to locate him, but at least an opportunity to be given to the defendant to come back and voluntarily participate in his trial. Having said all of that, after speaking with counsel, the court has made a determination to adjourn the September 30th, 2024 at 10 a.m. For closing arguments and final instructions to the jury. During that week period in time, in essence, the court is giving an opportunity for the defendant to reconsider his decision. Also to allow his counsel to have a conversation with the defendant as to what may be those implications of him having removed himself from the proceedings. But I think in fairness, and since they are monumental rights that the defendant would be forsaking in terms of leaving his trial, the court thinks that it would be prudent for the court to do so. That was long, however. Either counsel have anything to add or to say contrary to what the court has indicated on the record?
Nothing contrary, Your Honor.
Neither for me, Your Honor.
All right, very good. And I do appreciate both counsel being patient as the court was trying to think through this and also participating in trying to find something that would guide us. It was really truly appreciated on this court's behalf. So this matter is adjourned to September 30th, 2024, 10 a.m. for continuation of the jury trial. Thank you.
Thank you, Your Honor.
Don't go off yet. I should also note one other thing. The people had requested that I give to the jury an instruction to not talk to anybody, same instruction that I had given them during the opening statement, but just to reiterate that to them. And the initial thought was to bring them back out, give them that instruction, and then have them go. And I think it was correctly pointed out that Mr. Bloom not being present here may send some signal to the jury. I assured counsel after they had indicated that they trusted the court to give that instruction to the jury. I did do so. They each acknowledged that they understood that instruction before leaving. So,
Thank you, Your Honor. That's accurate. People wanted to be sure that they very understand that those, not talking to people and all those risks do continue during this term, and I appreciate that. Thank you.
thank you, folks. I think that's it. 14A stands adjourned.